Let's get started here. Good morning, everyone. Thanks for joining us. As we begin this morning, I'd like to acknowledge that I'm joining you today from the traditional and unsurrendered territory of the Abenaki people in the state we now call Vermont, and I'd like to offer this land acknowledgement. The Vermont Arts Council recognizes that we live and gather here in Indakina, the traditional and unsurrendered homeland of the Abenaki people, one of 5 Wabanaki nations who have had a continual presence here since time immemorial. Please join us in acknowledging their history and ancestors, their enduring presence, and their future generations that will live and gather here in Indakina. I'm Susan Evans-McClure, and I'm the Executive Director of the Vermont Arts Council. Welcome to the Vermont Creative Network's Regulations Report webinar. If folks want to introduce themselves in the chat, we'd love to know who you are and where you're from. So your name, if you're with an organization, your organization, and where you are joining from right now. I'm joining from my house in Heinsberg, Vermont. So the Vermont Creative Network is a broad collection of organizations, businesses, and individuals working together to advance Vermont's creative sector through research, advocacy, and networking. And part of building our sector, which is Vermont's 3rd largest economic sector, and which also builds thriving communities statewide. So part of building that sector is really making sure that we know all of the opportunities that are available to our creative businesses and nonprofits, and the rules we need to follow to do so legally and ethically and effectively. So today we'll be learning all about that with 2 true experts who can help us navigate these waters. Before I introduce them, I'll mention that we are recording today's webinar and it will be available on our website later, and you'll also receive an email with a link to view the recording. And today's event is also being live captioned by White Coat Captioning. To view the captions, click on the closed caption button at the bottom of the Zoom screen, then click on the Show Subtitles option. You can also select a full page view of the captions by clicking on the link that's posted in the chat box below. This will open the captions in a separate browser for you to view. And Deirdre just put that link right in the chat. We'll put the instructions in there too. So today I'm really happy to be joined by 2 wonderful people supporting Vermont's businesses and nonprofits across our state. Becky Wasserman, who's the Director of Economic Empowerment at the Office of the State Treasurer, and Heather Southwell, who's of counsel at Downs Rachlin Martin. So what we're going to do today is we'll have Becky do a presentation first, and then we'll have some questions for Becky, and then we'll turn it over to Heather, and she'll do a presentation and do some questions there too. You're welcome to put your questions in the chat as we're going. I'll monitor those, or you can save them and ask them live and in person once folks are done with their presentation. So with that, I will turn it over to Becky. Thank you so much, Becky, for joining us today.
Great. Thank you, Susan. And again, my name is Becky Wasserman. I'm the Director of Economic Empowerment in the State Treasurer's Office, and I'm really excited to be here today to talk to you about the Vermont Saves program, which is a program recently launched by the Treasurer's Office. I'm just going to take a moment to try to share my screen. Hopefully you all can see that. Great. So I know we don't have much time, so I'll just jump right in. Here's just a quick agenda for today. So I'm going to talk very briefly about why we have the Vermont Saves program. And then I'll talk about the requirements for both employers and employees. I'll touch on the implementation schedule, and then I can jump to some questions that we've been getting frequently, and then have a few minutes to answer any questions that you all have. So first, I just wanted to take a moment to look at the retirement landscape in Vermont. The reason the legislature passed this program is that Vermonters, like most Americans, are facing a retirement savings crisis. We have estimated that approximately 40% of Vermonters lack a workplace retirement plan, which amounts to somewhere around 80,000 private sector employees in the state. And you'll see that these percentages are more significant based on the size of an employer and the location in the state. So among employers with 20 or fewer employees, about 55% do not offer retirement benefits. And while about 60% of Burlington area employers offer a plan, only about 50% of employers in the rest of the state do. So this lack of workplace retirement plans is significant because an individual is actually shown to be 15 times more likely to save for retirement if there's a workplace plan in place. So for this reason, programs like Vermont Saves can make a big difference in expanding access to retirement savings. I just wanted to briefly touch on sort of the current status of these plans across the country. So we know that Vermont Saves will try to work to meet the goals that we're trying to, the policy goals that we have in the state, because Vermont is not the first state to enact such a program, which we call a state auto IRA program. So as you'll see, there are currently several active state auto IRA programs around the country, and Vermont is the 11th state to launch a program. And we have some other states that are just recently passed legislation in 2024. So this is really a concept that's kind of taking off all around the country. And I just wanted to note that in the spring of this year, Vermont announced that it was entering into a multi-state consortium called the Partnership for Dignified Retirement, and that's led by the state of Colorado, and also includes the states of Delaware and Maine. And so we have really benefited from this partnership because this has allowed us to get up and running more quickly. We've really learned from what others have done, and we've experienced a lot of cost savings and lowered fees as a result of joining this partnership. So into the details of the plan, who does Vermont Saves impact? Vermont Saves the law requires that all employers with 5 or more employees, and that means any employee who has a W-2 income attributable to Vermont, that does not offer a workplace retirement plan, must enroll their employees into the program. Employers must have been in business for 2 years to be considered required under the law to participate in the program. As for employees have to be 18 years old and have a social security number or an individual taxpayer identification number. And these last 2 requirements are because we're opening a Roth IRA account for employees. And these are federal requirements that are associated with opening this type of account. If you are an employer and you already offer a workplace retirement plan, then you are exempt from participation in Vermont Saves. For reference, I've listed here examples of qualified plans that would exempt you from the program, such as a 401k, a simple, or a SEP. So if you already offer one of these plans, then you are not required to participate in the program. And I'll touch a little more about that exemption process that you need to go through a little later in the presentation. In terms of the primary features of Vermont Saves, first, you need to know that it is an automatic enrollment program for employees. So what this means is that the employer automatically enrolls their employees into the program, and an employee can then choose to opt out if they don't want to participate. It is completely voluntary to participate in the program, and an employee can opt out or back in at any time. Another feature of the program is that it is a public-private partnership. So the Treasurer's Office is facilitating the retirement program, but we have partnered with a company called Southwell to serve as the program administrator and record keeper. So Southwell has a background in running these types of private programs and public-private programs, and they currently manage 9 of the 11 active auto IRA programs that I mentioned earlier around the country. Southwell partners with BNY Mellon, which is a large custodial bank. So all of the Roth IRA accounts that are open for savers are custodied at BNY Mellon. And then I just wanted to mention finally that our goal for the program is to make this as easy as possible for both employers and employees. And I'll talk a little more about the enrollment process next to see the steps that an employer has to take. So as an employer, you basically have 3 things that you need to do to comply with this program. First, you need to register your employees on the Vermont Saves portal. Second, you need to send employee contributions through payroll. And then finally, you have to do ongoing maintenance. And what I mean by ongoing maintenance is continuing to send those payroll contributions and then onboarding any new employees or removing any employees from the program that separate from your business. Based on my experience sitting in on these onboarding sessions, they take less than a half an hour. It's pretty quick to upload your employee information, and it's an pretty easy process. So in terms of employees, as I mentioned, the employee will be auto-enrolled in the Roth IRA account. The law sets a default contribution rate for employees at 5%, which will be deducted from their paycheck. The law also has an auto escalation provision of 1% per year up to a maximum of 8%. So that means every year on a certain date, the treasurer can decide to increase that 5% default contribution rate by 1% until it reaches a maximum of 8% per year. An employee will be notified of this each year, so it will not come as a surprise to anyone when this happens. And there'll be other options for employees if they don't want to participate in that default rate. We have chosen a default investment as well if the employee makes no other choice. So the way it works is that the first 30 days, an employee's funds are kept in a capital preservation fund, which is essentially a money market fund. And then it is moved after that 30 days into a target date suite of funds with an expected retirement age of 65. So these funds get more conservative as an employee reaches their anticipated retirement age. So I just talked a little about the default options of the program, but another main feature of Vermont Saves is that employees have choices about whether they want to participate, and if they do want to participate, what that looks like. So an employee can decide that now is not the time for them to start saving and completely opt out of the program. Or if they stay in the program, it's entirely up to them, the percent of wages they contribute and how they choose to invest amongst the options that we provide. So rather than that default of 5% that I mentioned, an employee can decide that right now they're only comfortable contributing 2%, or they could decide they'd like to save more for retirement and increase that contribution rate. Employees can also customize their investment options. So in addition to the target date fund, we also offer an international fund or bond fund, as well as a domestic asset class. So employees can have any mix between these funds that we have, 50% in one and 50% in another. Our website also has a lot of information about these investment options, so an employee can become informed about the investments that they're making prior to making those choices. Quickly, I just wanted to go through what the enrollment process looks like. So we have opened the program already. So we got a list from the Department of Labor of all the businesses and the nonprofits in the state that we believe are covered by our program. So we've started to send out notifications to those employers to let them know that. So last week, if we believe that you are required to participate, you would have received a letter in the mail or an email address if we have, an email if we have your email address on file, with an access code and instructions on how to enroll your employees. So you would then the next step would be to take that access code to the Vermont Saves portal and enter in the information into the portal. And then your job as an employer stops for 30 days. So in that next 30-day period, VESPL sends notifications to employees to let them know that they have been enrolled in the program and that unless they take action in the next 30 days, they will be subject to that default rate that I mentioned, that 5% of their gross check will get deducted and contributed to the Roth IRA account. So we let employees know that they've been enrolled and they have options. They can do nothing and have that 5% deducted. They can also customize their contribution amounts or investment options or opt out. So we communicate with them 3 times in that 30-day period to let them know of these choices. And after that period, they become enrolled in the program. And then this is when the employer's job starts again, where they, if they have an employee that decides to stay in the program, the employer is notified ahead of their next payroll after that 30-day period has ended of the contribution rate that their employee has chosen. so they know that they have to make this payroll deduction in their next payroll. So depending on your normal course of payroll, this could be 2 weeks after that 30-day period has ended, but the program will let you know ahead of time that you need to make those contributions through payroll. On this slide, I just wanted to show what it looks like to input your employer identification number and that access code that I mentioned that you'd be receiving by mail or email. So you would input your information here. And I just wanted to note that if you did receive a notification from us that you are required to participate, but you do have your own workplace retirement plan and you believe you're exempt from the program, you could simply log in on this screen here, and there should be a button for you to click that says, I certify that I'm exempt from the program, and that would exempt you from any further communication from us. I touched on this, but quickly, just some important dates to note. We did launch our pilot program in October, so we have 7 businesses that have already been enrolled in the program around the state. We opened statewide to all employers with 5 or more employees the first week of December, so last week. And then our enrollment ends at the end of February. So I have listed some frequently asked questions here. I do want to leave time for your questions, so I think this will get sent out. If I don't, I'll just touch on a couple of them. So the first one about who is an employee, I just wanted to stress that we are trying to make this as broad as possible so that as many employees can participate. So seasonal, temporary, and part-time employees are considered employees for purposes of that 5-employee count if they work 500 hours or more in a calendar year. Another question that we get often is, if you do offer a plan to some employees, but not all, like perhaps to your full-time employees, but not your part-time employees, are you still considered exempt? And the answer is yes, you are exempt if you have a plan, even if it's not available to all of your employees. And then I just wanted to note 2 things here on this slide. So right now we're sending out communications about enrolling your employees. If you enroll in the program and then maybe 6 months from now you have a new employee, the rules does say that you have 120 days from the start date of that new employee to enroll them into the program. And then finally, although we hope that this is not the case, I just wanted to note that the statute that creates the program does allow the treasurer's office to impose some penalties if an employer does not enroll and register in the program. So those range from $10 per employee up to a maximum of $75, and it increases up until October 1st, 2026. But we are hoping to do enough outreach and work with everyone to avoid that situation from happening. And with that, I have some contact information here for the treasurer's office, as well as for who you would contact at Vestwell if you are an employer or a saver, if you are part of the program. And I think this is going to get sent around, but I will try to figure out how to stop sharing. Okay, great.
Thank you so much, Becky. That was great.
Yeah.
We do have a few questions about eligibility. So the first one, love to see the enthusiasm for retirement plans. The first one is businesses or nonprofits who have less than 5 employees participate in this. Even though they don't have to, can they choose to participate?
So unfortunately, the law does not mandate it if you have less than 5 employees, but we do have an option to voluntarily participate. The difference is that if you have 5 or more employees, the participation goes through the employer. So it is the employer who is enrolling you, and you contribute through payroll deduction. If you as an individual who work for a business that has maybe 3 employees want to participate, it is just you as that individual would sign up. So you go to the website, and there's a way for you to sign up. And then your contributions would need to be made through check or an automatic deduction from your bank account rather than through your payroll.
So another question about that, there are a lot of artists and creatives who are independent contractors or gig workers. Can you talk a little bit more about how individuals can sign up and our contributions as individuals pre-tax as well?
Yes. So the way you would sign up is just, there's, if you go to the website, there is a way to just, sign up as a saver into the program. So you would just follow that process there to voluntarily participate rather than through your employer. Um, and I would note, because just on the topic of independent contractors, so if you are, let's say, an independent contractor for an employer who has 5 or more employees, we would not consider you to be an employee for the purposes of the program if you don't have a W-2 income. So I just wanted to make that distinction. And then I lost the second part of that question.
If you are an individual and you sign up as an individual and then you set up basically however the money gets into your retirement account, right? If it's a
Right.
direct deposit or you send a check, is that considered a pre-tax?
Oh, yes. So it's a Roth IRA account, so that's post-tax. And so what that means, so just a couple things on that. There are regulations imposed by the IRS on the maximum amount that you can contribute to a Roth IRA account. So even for voluntary participants or for employees who are enrolled through their employers, you will have to be mindful of that maximum amount, which is that's $7,000 per year, unless you're 50 or older, and then you get an additional $1,000. And if you are enrolled in our program, then you will get an alert that says you're kind of getting close to that $7,000 maximum. So you will be made aware of that. And then so and then the other point is it's post-tax, so you can withdraw. I mean, the goal is to save for retirement, but if you had an emergency, let's say your car breaks down or something, you can withdraw without penalty any of the principal amount that you have contributed into the account. So that's just another sort of benefit of how the Roth IRA account works post-tax.
Okay. So if you are an employer who does offer a retirement plan for your employees, is there any reason that you would want to switch into this program? Would there be potential cost savings for that as an employer? Is there a reason to centralize in that way and support the program?
So we actually, the law actually has some limitations on if you already offer a plan. So we're not trying to induce anyone who has a plan. So you can't have had one, I think, for the preceding calendar year. But for those that are sort of considering, opening their own employer's sponsored plan, like a 401k versus Vermont Saves, I mean, I think, it's just a decision you'll have to make about what makes most sense for your business. I think one of the reasons we're finding that this is popular for employers is that, it's no cost to the employer. You're not being charged any fees. There are fees, but they are based on their account fees that are paid through the savers. So there's no cost for employers, and it can also just be an administrative burden for employers to be managing their own plans, which is a lot of reasons why particularly small businesses or nonprofits don't have retirement savings plans.
Great, thank you. And just a clarifying question about folks who are being told organizations, if they need to or not need to sign up. So if you all have determined that an organization does not need to participate, they already offer a plan, would they receive a letter?
So we are just working with the best data that we have. So we hope that we filtered out everyone that does not need to participate. If you got a notification from us in error and you're not required to participate because you have a plan or because you have less than 5 employees, you can just go through that exemption process that I talked about. If you think you should be participating and you did not receive a notification from us, you can contact one of those numbers, the employer number that will be sent around, and get an access code and sign up that way. So, you know, we tried our best to capture everybody, but admittedly, I'm sure that there are some errors in the data.
So employers who have 5 or more employees are required to sign up. You'll get information about how to do that. For those who have less than 5 employees, those folks who want to participate can sign up as individuals. This is a really exciting thing for the creative sector, as often this is something we hear for independent contractors or individuals or really tiny organizations that you just don't have the capacity to offer this benefit. And this seems like an exciting opportunity for folks to get this, which we all need. There's one last question. If there's others, please put them in the chat or raise your hand or wave in some way. I'll look at everyone. Is there a way where folks can find out past performance of the funds as they are invested?
Yeah, so all the fund information is available on the Vermont Saves website. So there's some investment resources. So it has information on, there's, as I mentioned, a target date fund, bond index, international equity, and domestic asset class.
Great. Any other questions for Becky or about Vermont Saves? And I think I'll just put a link in the chat to the website, which I think is the website, for folks to check out more about that.
Yeah, so that's actually the webpage for the treasurer's office. So I will also put in the website to the program website as well.
Great, thank you. Well, thank you so much, Becky, for joining us today and for all that you're doing all around the state. As Becky said, this information will be sent out as the follow-up after the webinar, and you can reach out to Becky's team with any questions as well. If more questions come up in the next half hour, I can ask you later, and Becky will get the information. But Becky's going to sign off, and thank you so much for joining us.
Yeah, thank you. And yeah, feel free to reach out if there are any questions. Great. Thanks so much.
Becky. All right, I'm going to turn things over to Heather. Heather is of counsel at Downs Rachlin Martin, which means she knows all of the things about HR laws and regulations and can answer a lot of questions. So she's going to do a presentation on some changes that have happened and things we need to be aware of. And I will turn it over to Heather. We'll do the same thing. Folks can ask their questions. Sorry, I won't turn it over to Heather yet. We'll do the same thing. If folks have questions, you can put them in the chat or just ask them after the presentation. Heather.
Okay, can everyone hear me?
Yes.
I can see just one slide on the screen. Excellent. Okay, great. My name is Heather Southwell. I'm of counsel with Downs Rachlin Martin. I'm based out of Burlington. I've been practicing labor and employment law for almost 20 years now, but not always with DRM. I worked for the federal government for a long time, so not exactly a nonprofit and not exactly a creative sector business, but different than what I do now. What that means functionally, what I do day to day is I provide guidance, representation, litigation for managers, nonprofits, businesses in labor and employment matters. So that's what I do. This presentation is going to be relevant if you have any employees. You know, it doesn't need to be a lot of employees, but some employees. I'm just really pleased to be here today. So thank you very much for that, Arts Council, for asking me. What I'd like to do is just give a very high level overview of some legal updates and changes that might be relevant to you, especially as we're coming into the new year. So some of these things might be reminders, some of these things might be completely new. That's the construction going on in Burlington. I don't know if you can hear the sirens in the background. Let's start with the legal landscape. So I guess one of the first things I want to emphasize is that while there are some fundamental differences between creative sector businesses, nonprofits, and your general like for-profit corporation, right? There's going to be some different mission alignment. There are going to be some differences, but by and large, the same laws apply. And so it's really going to be a matter of size. You know, there are state and federal laws that apply to employers across the different spectrums of the businesses that we have in the state. So for instance, you know, there are discrimination laws, right, that apply to employers and laws against discrimination. depending on the size of your business, different laws might apply. So I'm sure you've all heard of the Family Medical Leave Act, right? That's the act that provides unpaid leave to people either having certain medical conditions or caring for people with certain medical conditions. So that's going to apply, whether or not you are a social service organization, arts education, making widgets or capacitors, if you have 50 or more employees. So that's the federal law that will require you to comply with that. But there's also a companion Vermont law. It's called the Vermont Family and Medical Leave Act. And so that's going to apply to you if you have 10 or more employees. So if you've got 50 or more, you're going to be under the federal law. If you've got 10 or more, you're going to be under the Vermont state law. And the laws are largely the same. Very, very similar laws, very similar requirements, but two different thresholds. So what if you have fewer than 10 employees? Well, then you're going to have to make a policy decision, right, as to whether or not you want to grant this type of leave to someone, even though you're not legally required to. And that's something that a lot of people decide to do. So the differences really are knowing, what size organization you are and what laws apply. The best way to ensure smooth operation and just good business, no matter what type of business you're running, is to make sure that you're in compliance with the laws and sort of you know what's going on from a labor and employment landscape. I know this can be challenging, especially when you don't have, if you're a smaller organization, you don't have like an entire HR department or legal department, staying on top of the updates. I get that. So what we're going to do here is just cover some like broad view things that might be applicable to you. The first thing I want to talk about is the Vermont pay transparency law. And so this is going to apply if you hire employees. This becomes effective July 1st of this year, and it will apply to you if you have 5 or more employees. So it's a pretty small organization. And what it requires is that if you make a job announcement, if you're hiring, you have to disclose the range of compensation in the job announcement. So why do we have this? Vermont's actually one of a few states that have recently taken up one of these provisions. We're actually the 9th state who has a Vermont a pay transparency law, and the idea is really to promote equity and fairness and transparency in hiring. So if you see a job announcement and there's no range of compensation, how do you know if you're being paid fairly enough, right? Like you don't know what the minimum is, what the maximum is. So the idea is sort of to try to promote equity and transparency. So each job, what we know is this, the Vermont Attorney General's office is going to issue guidance probably after the first of the year, I believe, about how this applies. But what we know is that, again, if you have 5 employees, it's going to apply to you. Your job announcements have to have a range of compensation. So what does that mean? It means the minimum and the maximum good faith expectation of what this job is worth or what the job pays. It's going to be probably, it's an hourly, like a minimum hourly range and a maximum hourly range. This doesn't mean that you are restricted to paying what you put in the announcement, right? So the law specifically provides that employers are not prohibited from hiring an employee for more or less than the range of compensation based on circumstances outside of the employer's control, such as applicants' qualifications and labor market factors. So what that means is that you can put out an announcement, it's got this range of compensation, and the people that you get are not exactly what you're looking for maybe. Maybe their qualifications are not going to merit the minimum, or maybe their qualifications are going to merit more than the maximum. So you don't necessarily have to be confined to this range, but you do have to announce it. A couple other things to note. You don't have to put in discretionary compensation, right? So all of your benefits, bonuses, those don't have to go into the announcement. This requirement will apply to any position that's internal, external, or both. So even if it's only like an internal promotion and you're like, okay, we're going to offer this within our organization, this requirement would apply. It applies to positions that are physically located in Vermont or a remote position that's going to predominantly report to Vermont. So if you've got someone working outside of Vermont and they're reporting to a business, like an office outside of Vermont, it's not going to apply. But if you're hiring for, a remote employee and they're reporting to you in Vermont, it would apply. Another thing to know, you're not required to use job announcements. So maybe the nature of your organization is that you do hiring a different way. Maybe you do a lot of word of mouth. Maybe you sort of have connections and you select people to hire. That's totally fine. You don't have to use job announcements, but if you do use job announcements, you're going to have to use through this format starting July 1st, 2025. In terms of enforcement, so there's no private right of action here. There's no, employees can't sue employers or organizations, but the authorization to enforce it comes from the Vermont Attorney General's office. So if you've ever had any interaction with complaints of discrimination, it's a similar process. So there'd be an investigation. The AG's office can impose civil penalties and restitution for those employees who are not paid fairly. So those are the remedies, but those remedies aren't going to happen to anyone on this call, right? Because not everyone knows about the law, and if it applies, you're going to apply it. Okay, so any questions about the Vermont pay transparency law? Or we can hold them to the end if you have any. The next law I want to talk about has already gone into effect. It is the Crown Act. Has anyone heard of the Crown Act? Any hands? Okay, so this went into effect in July last year, and it's interesting. It amends the definition of race in the Vermont Fair Employment Practices Act. And what it says is that race can also include traits associated with or perceived to be associated with race, including hairstyle, hair type, hair texture, hairstyles, protective hairstyles. So on its own, this is not a startling amendment to the Vermont Fair Employment Practices Act, right? So if you've got a law that prohibits discrimination, you're also not going to want to allow discrimination against characteristics that are associated with race, right? So this law makes a lot of sense. What's really interesting about this law is that it doesn't add, if you've dealt with discrimination complaints or issues, you have a bunch of protected classes in Vermont. You have race, sex, gender identities, and like tons of protected classes. The Crown Act does not add hairstyle as another protected class. It amends the definition of race to include these traits, which is really interesting. So if you have a EEO or anti-harassment policy, which I really recommend everyone have, you don't have to amend it. You just have to realize that, like, when you're talking about hair and like traits culturally or traditionally associated with hair, that is also a basis of discrimination. It's not separate, but it's included in the definition of race, which is pretty neat. Another reason I want to point this out is that if you haven't read the Vermont Fair Employment Practices Act, I would recommend you do it. I mean, it's long. Title 21 is long, and there's a lot of stuff in there, but it's by and large, it's written very clearly in sort of plain language. So, it's a sort of good overview of things you need to be thinking about as an employer in Vermont. Okay, employee handbook provisions. So this is a passion of mine, employee handbooks. I realize that not all businesses and organizations are going to have employee handbooks, right? Not everyone is quite as passionate about these. And also, you might not think you need them because you're a small organization. You've only got a couple employees. In Vermont, there's no requirement that you have an employee handbook, right? You're not legally obligated to do this. However, many organizations have employee handbooks for a couple of reasons, and we generally recommend them when we work with employers. The reason is it's not only good to set expectations, but it's really good to communicate your culture, right? There's no better, when an employee comes into the organization, you hand them an employee handbook, they get a sense of like who you are and what you represent. And it says a lot about the organization. So it's one good way to communicate expectations and sort of organizational culture. Another reason is that there's a lot to remember, right? I do this every day and I'm forgetting stuff all the time. There's so many laws. It's good to have a sort of guidebook, not only for employees, but for you to make sure everyone's on the same page. Let's see. If you don't have an employee handbook, there are a lot of services who provide employee handbooks. You could probably get one through your payroll company. I think a lot of payroll companies do that. I think that's totally fine as a basis to sort of figure out how you want to structure an employee handbook. I would say though, before you send it out, I would recommend that you get either counsel or someone who's very experienced in HR to take a look at it, just to make sure that the laws that you include are the right laws, are the most up to date, and that it really is communicating your voice as a creative business or a nonprofit. I also recommend that they get reviewed once a year, right? Because things change. This Vermont Pay Transparency Act came into place. The sexual harassment policy, that's changed in recent years, and I want to talk about that. Because if you haven't updated your handbook to include these changes or your policy, you really should. There are two, okay, if you don't have to have a handbook. If you do have have a handbook, they have to include these two provisions. They have to include a sexual harassment policy, and they have to include a Vermont paid sick time policy. Handbooks in reality include a lot more than this, but these are the two that have to be included. Even if you don't have a handbook, you have to comply with these laws. The sexual harassment policy changed a few years ago. So if your sexual harassment policy says that sexual harassment has to substantially interfere with your work, that's outdated. Now only has to interfere. If your policy says that it has to interfere with someone's performance at work, that's also not accurate anymore. It's a much lower standard. It just has to interfere with your work. You could be at work, you could be performing wonderfully, but you could still be sexually harassed. So that's what this law recognizes. And it also, the conduct doesn't have to be severe or pervasive. That's a standard that comes from federal law. And federal law on this point is much more restrictive than Vermont law. In other words, the threshold to meet a claim of sexual harassment is much lower in Vermont. So it really has to only be conduct that's unwelcome that interferes with somebody's work. So you want to know that. If your sexual harassment policy is referring to the old standard, you'd want to have to amend that. The Vermont paid sick time policy, this is a big one too. This is mandatory. Employees who work at least 18 hours per week have to get 1 hour paid sick time for every 52 hours worked. It doesn't have to be phrased like that. If an employer has some sort of combined time off or paid time off, that satisfies this requirement, but you have to do the math, right? Is your paid time off or combined time off formula such that it's meeting this requirement of 1 hour paid sick time for every 52 hours. So again, this is a lot to keep track of, but these two policies are policies that all employers are required to comply with. I now want to talk about some standard forms and policies that you may or may not have, but good to think about as you get to the end of the year. And the reason I highlight this is because if you have to generate these from scratch each time you use them, it takes a lot of time. And creative businesses and nonprofits have a lot of passion, a lot of resources sometimes, but not a lot of time, right? So I think in general, if you've got standard templates that you can use and update every year, that's probably going to save you a lot of time as an organization. So I would recommend taking a look at these as you do your end of year review to see if there's anything that you are missing or anything that might be beneficial to you. Organization charts are good. Hopefully you never have to use discipline forms or termination letters, but it's better to have thought through those in advance and have them before you have to use them. Okay, and then we're going to talk about classification reviews. So, gosh, classification reviews. Have any of you dealt with the FLSA, Fair Labor Standards Act? No? Okay, so it's going to be there are thresholds for the Fair Labor Standards Act. It applies to private, public employers, nonprofits. If you have a certain threshold, the threshold is generally, I think it's $500,000 in commerce, or if you engage in interstate commerce. So that could be for a bigger organization, or could be for an organization that engages in interstate commerce. And the Fair Labor Standards Act talks about the minimum wage and overtime requirements for employees that are exempt and not exempt. This is an area where there's been a lot of activity lately. The Department of Labor enacted a rule that was raising the salary threshold for finding someone exempt from the Fair Labor Standards Act under this, we call it a white collar exemption, executive, administrative, or professional employees. When you're looking at exemption under the FLSA, you look for salary and you look for duties. And the Department of Labor had proposed a rule raising the salary threshold to be exempt. It's going to be on January 1st, 2025, the threshold was going to be $1,120 a week, or about $58,000 annually. So if you met that, you could be exempt from the overtime and minimum wage requirements. That rule was blocked recently by a federal court in Texas, I believe, the Texas U.S. Department of Labor. And the court said that, the Department of Labor has discretion to define and delimit what is an exempt employee, but not increase the salary cap. So that increase is currently on hold, and right now the cap is back to $35,568 annually. So I expect there'll be more activity in this area, but I just want to let you know that the FLSA is an area with a lot of action. In addition to that change, or that change that didn't go through, I want to talk about classification reviews and how they could be applicable to you. So ideally, anytime you add a new, if the FLSA applies to you, and there is a fact sheet, if you look at fact sheet 14, you can just Google fact sheet 14 FLSA, and you can figure out whether or not the FLSA is going to apply. It's a good idea to do a classification review anytime you add a new job, or anytime you, once a year, if job duties change. As a quick review, you'll have employees who are either classified as exempt or non-exempt for the minimum wage requirement. And employees who are exempt have to be paid, these are your overtime employees, right? They have to be paid at least 1.5 times their base rate if they work more than 40 hours a week. So they're entitled to overtime, they're entitled to be paid the minimum wage. Then you have exempt employees, these are executive, administrative, professional employees who the minimum wage and overtime requirements are not applicable then. So these are people who are generally, but not always, on salary. The expectation is they can work as many hours as they need to, but they're not necessarily going to get any overtime. So there's 2 different types of employees. Sometimes employers like to classify people as exempt. Why would they do that? You don't have to pay overtime, right? You can make them work as much as they want. They don't have to pay overtime. So that's a bad practice, right? You have to make sure you're actually in compliance with the law, because the consequences of misclassifying an employee can be really severe. So if you have an employee who you say, well, you're exempt, I'm not going to give you 1.5 times overtime or the minimum wage. If the Department of Labor comes in and does an audit, you could be subject to bad wages, liquidated damages, which are doubled, back pay, attorney's fees, that kind of thing. So it's important to get it right. This is what I've outlined here is sort of basic structure for doing a classification review. You look at the duties this employee is actually performing. You look at the job description. You look at what the employee is actually doing. You look through DOL fact sheet 17A. You could just Google it. It's also in the regulations. It sort of lays out what the salary test and the duties test that each employee has to meet to be exempt under the Act. So first, you just want to review all the positions, what people are actually doing, and compare it to the test. Then you want to look at any problems. Do you have someone who's working more than 40 hours a week? They're maybe not meeting the test for executive, administrative, professional employee, but they're also not getting paid overtime. You really want to look at that. If you identified some problems, you really need to make a plan on how to deal with it. Are you going to reclassify this employee? I mean, that's sort of one set of choices. If so, how are you going to do that? What are the implications of reclassifying them? If you go through a review and you find that you have some disconnect between the exemption test and what the employees are actually doing, I would recommend reaching out to counsel. Any communications are attorney-client privilege. We can certainly help you go through the classification analysis and figure out some options. Again, that's sort of like higher level stuff, much more than the Vermont Pay Transparency Act. But if it applies to you, it's pretty serious business. It can take some time. That was a quick overview, like a super light speed overview of some of the changes that might impact you in the coming year. I do have the slides will be circulated with the citations. If you have any questions, this is where I can be reached. If you have any questions now, I'm happy to talk through them.
Thank you so much, Heather. Yeah, if folks have questions, you're welcome to raise your hand or put them in the chat. I just wanted to highlight again the exempt classification. That was actually one of the main motivators for this webinar, is that people came to us last year and had so many questions about what was changing and what's not changing and how they can keep up. And just to reiterate for everyone, that change is not happening. So the rules are the same in 2025 as they have been previously in terms of exempt classification. Is that true?
Yeah, we're back to 2019. We're back to our 2019 levels. So yeah, there have been sort of increases. There's an increase in July, I think, and another increase was supposed to come in January. No, that's not happening now. Yeah.
We do have one question about any recommended sources to get started drafting that list of documents. That was a really helpful list that you recommended folks just have. having run nonprofits where I too have Googled like template form for this thing. Are there reputable sources that you can recommend to get started on those?
Yes.
Do you Google things like that, Heather? Where do you Google?
Yeah, Google's good. Google's got the law. No, you can absolutely Google, and then you can reach out to us for here. But if you can't or won't do that, or you don't want to do that, I would recommend SHRM, the Society for Human Resources Management. Right, I have a subscription there. You can go on. They have templates. They have articles. Yeah, I would recommend SHRM. They're a great repository of resources. I'm not sure how much the annual subscription is, but I would say if you're running any sort of business where you deal with people, HR issues, it is well worth it. It is well worth it for the subscription. Yeah.
There are also, sometimes your payroll service can also have access to some HR support or assistance that you might not even know you're already paying for as a nonprofit organization. So you can reach out to your payroll service too.
Absolutely. Yeah, a lot of times they do handbooks too. Now, I have opinions on some of these handbooks, but still, as a starting point, yes, if you're already paying for it, you should see what they're offering. Yes.
That's great. Any other questions that folks have? Well, Heather, I really appreciated both how you shared some information about the rules, but then also mentioned that the value of following the spirit of the law too. Often organizations in Vermont are smaller than are required to follow some of these federal and state laws, but when possible, that there are a reason that we have these HR laws and labor laws, and it's also valuable for even smaller organizations to follow the spirit of the law and be protecting employees also is important, and I appreciate you bringing that up too.
Thank you so much. I appreciate it. Thanks for your attention.
All right. Well, if folks have more questions, you're welcome to send them after as well. As we said, we'll send out the link to the recording and some resources that we shared in the coming week or so, maybe more than that, depending. It's coming. And just a big thank you to our speakers and to everyone for participating. We really appreciate the time that it takes to learn all of this. It can often be it's certainly outside of what I officially was trained in how to do, but it's a really important part of all of our jobs. And we appreciate everyone in the creative sector focusing on it. And please keep in touch, and we look forward to supporting you all as you move forward on all of these changing regulations, which will continue to change, and we will be here to continue to explain them. So thanks everyone for joining today, and look forward to seeing you soon. Bye.